Hello, everyone. Good afternoon. My name is Lisa Chavez, and I'm the Director of the Office of Research and Institutional Accountability at the State Bar. And this is the meeting of the full ad hoc commission of the discipline system. Before I take roll, I'm going to take a moment to see if any of our commission members are in the audience. So Kelly and I will take a look for that. So bear with us, please. In the gallery, that's where you look. No, not the gallery. Attending view. Kelly, can you see who's in the audience? Wait. Let me see where I look for people. Participants. Okay, click on the participants and the attendees. Okay, I don't see any commission members in the attendees, Kelly. Okay, terrific. Okay, so we're just going to go ahead and take roll now. Anderson? Bell?
Here.
Buenaventura?
Here.
Buffington?
Here.
Chen? Duran?
Present.
Rashadi? Barwell? Good?
Here.
Jones? Joseph? King? Okay, Michelle Anderson?
Yes.
Okay, terrific. All right. I'll go back to you. Okay, continuing on. King?
Present.
Larkin?
Present.
Lawrence?
Here.
Lear?
Present.
Mayorga?
Here. Present.
Pierce McGill? Okay, I think he's going to be joining us shortly. Moad?
Here.
Nakau?
Here.
Pansky?
Here.
Rosenblatt?
Present.
Schneider? Slig?
Here.
Stallings?
Here.
Wang?
Good afternoon. Present.
Winfield? Winfield? Okay, so we have 18 present. Chair Stallings, you have a quorum.
All right. Thank you, everybody, for being available today and what hopes to be our final meeting. Not that we don't enjoy seeing everybody, but the work has been very involved, very difficult, and want to personally thank each person here who has dedicated so much of their time and their schedule to looking at the discipline system and examining all the various reforms that we've discussed. Before we get into any discussion, though, I do want to make a call for public comment. And so if you are here on the Zoom meeting, please indicate your willingness to address this commission by raising your hand. You'll have 3 minutes to do so. And I'll have staff call on those members. If you're on the telephone line, please use the function.
Okay, it looks like Brandon is frozen for a moment, but for now, I don't see any hands, but let's okay, let's wait for him to come back. So far there are no hands raised, so it looks like we'll have no public comment today. We'll just wait for Chair Stallings to join us. Oh, wait. Oh, I saw a hand briefly, then it went down.
Sorry, I may have frozen there. Lisa, am I back?
You are back, and I don't see any hands raised.
All right. I may have to shut off my video so because of bandwidth issues, so my apologies. All right, so we will move on then to our agenda. And what I wanted to do is take a couple of items out of order. So as you'll see on item B, this is the adoption of recommendation regarding progressive discipline. This is a revote due to quorum issues that were determined after our last meeting. So Lisa, do you have anything briefly you'd like to say?
Yeah, let me just pull up my PowerPoint and we can make that adjustment right now, Brandon, so everyone can see. So here are the 4 items that we're discussing today. And so we can move, you're saying you'd like to move things out of order?
Yeah, so if we could do item B.
So this will go first, okay?
And then item C.
Okay, whoops. This will go second.
And then item A will be the third on the agenda, and then review and approval of commission final report before.
Oops.
If that messes you up too much, then we can go with how you had it.
This should be fine. Okay. Okay, Brandon? Okay.
All right.
All right, so okay, terrific. So let me just go ahead and let me share my screen. So as Brandon mentioned, this is going to be the order of our agenda for today. So we're taking things out of order. The first thing we'll do is do a revote regarding the progressive discipline recommendation that's the commission voted on at the last meeting. And the next we will we'll follow by these 3 items. The last item is called review and approval of the commission final report. And I just wanted to tee this up for you briefly. And that review process is going to focus on the report that we posted on the 12th of this month. We're going to discuss edits that have been proposed by members thus far. So I'm going to share my screen and show you those changes that have been made and track changes. And then we can discuss any substantial edits that you have so far we want to discuss today, and then we'll just confirm the recommendations adopted today. So that's the game plan for our today. But before we get started on our work, I just want to share with you the next steps. So on September 22nd, later next month, the Board of Trustees meeting will be held. It's the regular meeting, and Chair Stallings will present the final report to the board. And at that time, the staff will request for the board to officially agree that we will post the report for a 60-day public comment period. This is kind of a typical thing that we do for high-profile commissions that are proposing recommendations, et cetera. We post it for a 60-day public comment period. And then the plan is for in December or early January of this year, this commission is going to need to convene one more time so that you can review the public comment on your report. And so the idea is that, and this is again, we've done this for like the paraprofessional working group, et cetera. That's the process. And I am so sorry we didn't share this earlier. So Brandon, you said today was the last meeting, but actually this next meeting will be the last one. And so you'll review, so staff will summarize all the public comments, and you will have an opportunity to consider revising your recommendations in light of those comments. And then in January of early next year, at the next board meeting will follow that, staff will update the board with a summary of the public comments and any revised recommendations this commission may have at that time. Okay, does anyone have any questions on our step forward or on our path forward? Okay, terrific. Okay, so let's move on to our first item on the agenda, which is to consider for adoption the recommendation regarding progressive discipline. And as I noted in the report that I shared with you, as well as my email communication, staff reviewed the video from your June 1st, 2022 vote, and we determined that it needed to be invalidated due to the lack of quorum that existed at the time that vote was taken. So here's the recommendation that you reviewed, and it's the exact same recommendation. And I'll hand it over to you, Brandon.
All right, so are there any members of the commission who wish to have further discussion about this, this recommendation? I'm just going through the participant list. I do not see any hands. All right. May I have a motion then?
I move to adopt the recommendation.
All right, first by Ms. Pansky. Is there a second?
I second the motion.
I'm not sure who got that first. I'm going to go with Mr. Larkin as a second. All right. Can we please take the roll?
Yes. Anderson?
Yes.
Bell?
Yes.
Buenaventura?
Yes.
Buffington,
Yes.
Chen, Duran,
Yes.
Rashadi, Farwell, Good,
Yes.
Jones, Joseph, King,
Yes.
Larkin,
Yes.
Lawrence,
No.
Lear,
Yes.
Mayorga,
Yes.
Kirsch McGill,
Yes.
Moad,
No.
Nakau,
Yes.
Pansky,
Yes.
Rosenblatt,
Yes.
Schneider, Selig,
Yes.
Stallings.
I'm chair, so I have no vote.
Okay, great. Wang,
Yes.
Winfield. Okay, motion carries with 15 votes.
All right, thank you.
Okay.
All right, so now we're going to go down to item C, which is proposal to amend previously adopted recommendation regarding display of attorney discipline on website and expungement of discipline records. Lisa, can you give just a brief summary of where we are up to this point? And then I think we'll hand it over to Ms. Rosenblatt.
Okay, so at your June 1st meeting, this commission passed 2 recommendations with regards to timelines associated with the display of attorney discipline on the website, as well as expungement of discipline records. Subsequent to that meeting, Ms. Rosenblatt got in touch with me to share her interest in having this group reconsider that those recommendations and to amend it, in particular amend it. I instructed her to write up her summary as well as an alternative recommendation, and I share that with you all. Rather, it was posted to the agenda item. It was posted to the agenda for you all to read. Her proposed amendment as well as her rationale. So maybe we can hand it over to Eloise now.
All right. Yes, Ms. Rosenblatt.
Thank you very much. I've never made an amendment before, and I am a new member to this commission. So please receive this with any qualifications that are necessary. The record of my intervention is on page 30 of the draft, 30 and 31, where we talked about expungement of the attorney discipline record. And there was a report summarizing our discussion that there was on June 1st, commission members engaged in rigorous discussion about both topics, and staff provided clarity in response to questions regarding what expungement of discipline records meant in practice. Records are not destroyed when expunged. However, attorneys would no longer be required to report discipline, nor would the state bar report on expunged discipline in response to inquiries. OTC would continue to access expunged records as they apply to the imposition of progressive discipline. Nevertheless, one member, which was me, expressed concern about the impact the proposal would have on public protection, particularly in situations where attorneys have been convicted of domestic violence. And that was in response. I remember it was kind of an informal give and take. I had asked Ellen Pansky what kinds of misdemeanors would be considered. And she said, DUIs and some DV. I have a family law practice for the last 15 years as a second career attorney. And I am a certified domestic violence advocate since 2004. So many of my clients, I have sought petitions to propose their petitions for a restraining order because anywhere from ages 20 to 82. So it's a wide range of women for whom I have sought domestic violence protection. So my proposal was simply to exclude. The proposal is that any record associated with an attorney's misdemeanor involving domestic violence, including the record of a restraining order, and I list the Penal Code 273.5, which is battery as a felony or misdemeanor, and Penal Code 243, battery is a crime of moral turpitude, or Family Code 6320, which has recently been amended. But basically what I want to propose is that anything having to do with domestic violence be excluded from the expungement, the ENEC or expungement, because of the implications for the safety of the public. And I offered several rationales. Would it be okay, Lisa, if I just summarize those?
I leave that to Brandon Stallings.
Sorry, Ms. Rosenblatt, what was your question?
My question was, can I summarize in case, because I proposed this some time ago, could I summarize the rationale?
Yes, you can summarize. How long do you think your summary will take?
About 5 or 6 minutes.
Okay, yep, that's fine.
Okay. The first reason that I would want to bracket domestic violence, anything having to do with domestic violence, either under the penal code or under the family code, is because by the time domestic violence gets to the court, it's the tip of the iceberg. Domestic violence is a pervasive offense that affects 1 in 5 women nationally, and 98% of the victims are women. It's underreported like rape, and so by the time a complaint reaches the court, with the declarations, there's a lot of factual complaints and concerns over a long period of time by the time it gets to the court. So it's not like an arrest for a DUI or arrest for possession of drugs. This has had a long history, it's relational, there's always a victim. By the time it's a misdemeanor, if it's categorized as a misdemeanor, it has often been pleaded down from, a strangulation, which is always a signal that, it puts a woman at risk of death. A strangulation can be pleaded down to simple assault. And why? Because if an offender has a domestic violence record, they cannot carry a gun here in California. And if the person is a peace officer, a policeman, or in the military, or a security guard in a prison, that would affect their job. Or they can be liable for deportation if they are an immigrant. So there are many reasons why family members, or why a spouse or a girlfriend, a mother if the guy is the biological father of a child, why this is pleaded down so that they can remain and provide support. So in other words, a misdemeanor in domestic violence carries a whole freight of offenses and then another reason why I want to propose that there be a kind of a bracketing of domestic violence from the expungement considerations is that the family code has recently been amended to include coercive control as opposed to physical action. So coercive control under the family code 6320 includes things like restricting a woman's or girlfriend's access to other people, threatening them with reporting them to immigration, controlling their finances. So these things are not physical actions, but they are pervasive control actions. I am sympathetic to Sarah Good's and the whole commission's concern about racial equity. But the fact is that 3 times as many women who are women of color, Black women, women of color, brown women, women of color are 3 times more likely to be victims of domestic violence. That means that I think there's an unintended consequence of including some DV as a possibility of being expunged, because that puts women of color at greater risk, because there's a high recidivism rate among persons who have been convicted of domestic violence. It takes many forms. It's one of the most creative forms of offense under the penal code. I think that white women, as well as women of color, have a right to know if someone has, if a man who is an attorney has a history of anything connected with domestic violence, because while it may be, I think this is that there's a gender specific or gender associated feeling. A man may not feel that he has to protect himself from an attorney with a domestic violence record. He may feel that he has a brother who understands his own situation, but a woman will smell this differently. And anything having to do with domestic violence, a woman knows if she's alert, if she's seeking legal counsel. I think she has a right to know to protect herself because of all the forms that domestic violence or abuse can take in any relationship, and it does not necessarily have to be physical. So I would recommend that the state bar consider risk management, that if it fails to warn, it opens itself to not just a tort lawsuit, but a class action. I think those are some of the main reasons that I want to propose that we consider just bracketing anything having to do with domestic violence from the state bar's consideration of expungement, and leave it. I think the appropriate jurisdiction for expungement is to leave it to the state court, which can review the declarations which itemize which mention the specific offenses and the particular need for a protective order that this woman sought.
All right, Ms. Rosenblatt, thank you for your comments on this and for your work in this area. In order for your motion to get to debate, I believe we need a second. Is there a second for Ms. Rosenblatt's motion to amend the expungement recommendation?
I see Janet King's hand raised. Janet, are you seconding?
Yes, I am.
Okay, second by Janet King. All right, so in order to debate this, it's going to be limited solely to the new issues that Ms. Rosenblatt brings up. And so does anybody have any questions either for staff or for Ms. Rosenblatt, the proponent of this amendment?
See, Ray, go ahead, Mr. Buenaventura.
Yes, thank you very much. Obviously, I want to thank Ms. Rosenblatt for raising the issue, which I think is an important issue. But I don't agree with the motion, and let me tell you why. And again, no one is saying that domestic violence is not a serious issue for our communities. It clearly is. But at least from my perspective, as a 30-year practitioner in criminal law, what happens in domestic violence cases, and when it comes to the point, particularly in misdemeanors, as was discussed, there's actually a lot done when you get to that point. So if you get to a point where a defendant pleads guilty to a misdemeanor domestic violence, what ends up happening is, first of all, they have a right to an expungement, even after they're put on probation and they serve their time. So even in the criminal context world, you can apply for an expungement even on domestic violence cases. Secondly, when it gets to a point where someone pleads guilty to domestic violence, there are a lot of protections for the victim in those cases. For example, they are often, meaning the defendant is often denied a restraint, is often given a restraining order so that they can't even contact the victim in the case until and unless it is approved by the judge and the victim to have some kind of peaceful contact. In addition, it is a mandatory of 104 hours of domestic violence counseling that is always imposed on the defendant, and very often the judge won't allow any contact, at least until some of that domestic violence counseling is actually done. In addition to that, most jurisdictions have what they call domestic violence review court. So that defendant actually comes into court periodically, sometimes every week, every 2 weeks, or every month, to see the progress that has been made with respect to domestic violence victims. So it's a lot that's being imposed on the defendant, which rightfully should be. But it does take into account the protection of the community, the protection of the victim. And in the end of that whole process, if they've complied with everything, expungements are usually granted. So that's why I think, even though there are valid concerns, I believe Ms. Rosenblatt has raised, a lot of those have also been implemented in the criminal justice system, which the end result is still an ability to get it expunged. So that's why I don't think we need to carve out an exception. But again, I appreciate Ms. Rosenblatt and your concern, but I also do think that the disparate treatment of defendants that will affect some targeted populations. So thank you. That's my comment.
Thank you, Mr. Bonaventura. Any other questions for staff or for the proponent of this amendment?
Next, Ms. Mayorga, go ahead.
I don't have any questions. I just have some comments. So we can take questions first if anybody has them.
Go ahead with your comments.
Okay, thank you. Like Mr. Bonaventura, I think working in the criminal field, we have a unique perspective, and I do appreciate and acknowledge all of the concerns Ms. Rosenblatt has brought up, as I do think domestic violence is very important and something that takes very careful consideration. But as Mr. Bonaventura was saying, my concerns to the amendment my first concern would be to the restraining orders. And the reason I say that is because in restraining order court and family court proceedings, people who are defendants in restraining order proceedings do not have the right to counsel. So a lot of times they don't know the system, they don't know what's going on. Restraining order courts are very different than criminal courts as far as the evidentiary hearing parts and what's allowed in there as far as hearsay. So oftentimes as a criminal defense attorney, I see restraining orders that are put into place where people didn't have the proper representation, and it not saying that the restraining order wasn't valid, but they didn't have the opportunity to fight against that restraining order properly. And they may get imposed even though criminal offenses are ultimately dismissed. And so that's my concern as to the restraining order issues. As to the domestic violence convictions, I'll echo everything Mr. Bonaventura said, and also just put an emphasis on the reason that this ad hoc commission was put into place was for the racial disparities that we saw in the attorney discipline. Those racial disparities are 100-fold in the criminal justice system. So I think it would have an unfair impact on defendants or respondents of color. Additionally, from practicing, I know that by the time you get to a conviction, a lot of things are put into place, as Mr. Bonaventura said. And also, a conviction doesn't necessarily mean that something happened. I think we all know how the criminal justice system works. And if someone's in custody, they may rush to enter a plea without taking proper consideration of the lifelong impacts of that. Additionally, the impact would be that they could also get expunged, as Mr. Bonaventura said. So I don't think we should not have expungement when they're allowed expungement in criminal court. Further, I'm not sure on the connection between domestic violence and someone seeking an attorney. I think it's a slippery slope. And in that case, you know, we should consider ruling out expungement for anything that's assaultive, any 242, simple battery, assault, a misdemeanor, just regular battery. I think that has more of a connection than domestic violence, as that's an intimate partner battery or abuse, and we're not going to see that in a relationship between an attorney-client. Presumably they would be strangers. So I think it's a slippery slope, and we may not be able to stop it at a certain point. So those are my comments.
All right, thank you. Judge McGill.
Thank you, Mr. Stallings. So really, more of a question to staff. When you were surveying, I think you surveyed other state agencies on their approach on expungement records, particularly the medical board. And I don't know if you looked at what other states were doing, but is it possible to go back and research if this hasn't been looked at? I think it's an important issue, like the other speakers have said, and see how, or did the medical board consider this as possibilities? I think a lot of the issues that Ms. Rosenblatt raises regarding wanting to know about these types of issues with potential attorneys, I think would probably apply to potential doctor-patient relationships. So perhaps there could be some research or more looking into the issue of how the medical board or other agencies in other states approach a similar issue, so we can at least see what's going on out there. Thank you.
Lisa, do we have any of those stats available?
We just have the stats on, you know, which states and, you know, expungement, which boards expunge, but we did not explore whether or not there's particular you know, exceptions to expungement. No, we did not. Or anything that's excluded from expungement. No, we did not.
Okay.
Okay.
All right. I think that's certainly something that can be addressed further on down the road in public comment. So whether or not this item is adopted by the body today, certainly there can be minority opinions that are attached to our final report, and then further public comment can be obtained down the road as the board also grapples with these decisions. Let's see, next I have on my list is Mr. Larkin.
Thanks. I find myself in an awkward place. I was one of the persons who voted against the recommendation that Eloise is attempting to amend. So I opposed both the display, the elimination of the display after a certain period of time, and also the expungement of record. I understand Eloise's concern. I think domestic violence is an issue that's so serious and persistent, at least by what I understand. But I really have to kind of land back where I was before. I oppose the entirety of it, so I probably will abstain in this case. I don't think there are other states that expunge the discipline record. There are 3 other states, or at least 2 other states that suppress the display. But I'll be interested in what staff uncovers in that inquiry. So I just think this is a innovation that does not have an analog anywhere in the lawyer disciplinary agencies across the country, except for the display issue in Florida and Texas. That's my comment. Thank you.
All right, thank you, Mr. Larkin. Ms. King.
Hi, thank you. I just took a few notes. I appreciate that there is protection for the victim. But I also question, one of the aspects is for transparency. And what about the future offenders? It would be good to know if somebody was accused of this and charged. I understand there are 104 hours, but I also understand that this is a very frequent repeat offense. No matter what the consequences are, there's a lot of repeat offenders. I don't have a stat for that. I think as far as in the legal profession, there's a lot more increased odds that they would be able to battle a domestic violence. I consider that very few people are calling people out as well as being charged. I think there's a grander scheme than what we see in the legal system. And I think overall it would be great to exclude this from expungement. Thank you.
All right, thank you. All right, Mr. Moad.
Thank you. I am going to do my best to respect Chair Stallings' request that it only be on the new topic and not on the overall, but I was deprived of an opportunity to speak on the initial recommendation, the overall recommendation, because the meeting was held when I was at a conference and I was unable to attend the meeting. So I will just sort of briefly say that I opposed the original recommendation for the same reasons that Jerry stated. I do understand that the approach is more consistent with the current criminal justice trends. I'm not exactly sure that that was our charge, was to align our approach with the current criminal justice trends. And I think that our situation, the attorney discipline system, is distinguishable from the criminal justice system. Further, as a result, I'm not sure that such alignment is appropriate. For the reasons stated, frankly, by other commenters here today, I think that, for example, somebody who is looking to hire an attorney may want to know whether that attorney had previously been disciplined for misappropriation or other things and along those lines. And so I think there are a whole host of reasons that this is not the best road to go down. I've said this before, and I will forgive me for repeating myself. I spent 5 years managing, among other units, the consumer protection unit of a local district attorney's office. Both in my time there and in my 5+ years with the bar, I consider myself a consumer protection attorney. I cannot imagine that the public would think that we are doing a good job of protecting them, the public, by hiding from them information about prior misconduct committed by an attorney that they are considering whether to hire. I think the same is true if the commission decides to make such information more difficult for people to find by removing it from the website and making them call people at the state bar to find that information out. So I do oppose the underlying resolution, and for the same reasons as Jerry stated, I may end up abstaining from this one, but I do understand the seriousness of domestic violence.
All right, thank you, Steve. I see one more hand, and I hate to limit debate. I do want to be mindful though of the schedule and the other topics we have to talk about. So Ed, I'm going to have you go next, and then Eloise, just if you have any brief responses to any of the concerns raised and any final words, and then we'll put it to a vote.
Thank you, and I'll just be brief. The rant that I've had and many of the State Board Defense Council have had for years is this idea that you can have a respondent who has had a criminal conviction expunged through the criminal justice system, and yet that criminal act or that criminal conviction nevertheless trails that respondent for the rest of his or her career as a result of being posted on the State Bar membership website. And so there's always been that inconsistency in my mind. I think we need to trust the criminal justice system. And in that regard, my comments go not just towards the expungement issue generally, but also to the domestic violence issue. So that if the criminal justice system sees fit that somebody who's been convicted of a crime can have that misdemeanor or even felony expunged, then I think that it's the right thing, the fair thing to have that, for that person to have the opportunity to have an expungement through the State Bar system. Thank you.
All right, thank you. And then Ms. Rosenblatt, any brief comments regarding your position?
Thank you. I want to qualify and actually agree with Ed Lear. because the last part of my proposal is that the amendment is that the state bar does not initiate expungement of DV and restraining orders from the attorney discipline records. So rather, the expungement of DV records is reserved to procedures of a state court of proper jurisdiction. So I have exactly, in other words, the proper jurisdiction for expungement is the state court or where the crime was, where the person was convicted of a crime, or the family court. There are procedures, for expungement in state court, in family court as well, and for expungement of these records. So, but I'm just saying, my proposal is that the state bar does not replace, offer to in something so similar and pervasive. And I'm sympathetic to the concerns of criminal defense attorneys. I practice not in criminal court, but in family court, which is, allows a much more expansive understanding of what domestic violence and domestic abuse is. So, but I would say, I have already qualified my proposal by saying that the state bar does not initiate the expungement, but certainly if the expungement has been properly applied for and adjudicated through a state court, certainly. But my concern is that that the state bar was assuming universal jurisdiction to no matter where the conviction came from. So I would qualify that, but I also would support, our continued, since there are a number of persons on the committee that have acknowledged that this is a serious issue, that maybe we need to find out what other state courts do, and our understanding of, I think, two strands of where a domestic violence conviction can come from, both from family court and from criminal court. I haven't heard, I think I may be the only family court practitioner, but I would encourage, if we have time, or if there's a subcommittee that could be created, or just to address this so that we are protecting the public, that, as Stephen, Mr. Moad said, consumer protection is really the purpose of the state bar, to protect the public. What are we protecting them from, and how will we do that fairly to both, to men and to women? We have to protect both and be fair to both. I mean, this is not just a matter of legality, but of equity. So thank you for your comments. And I hope that, I think my bottom line would be to say, can we continue this rather than just have a vote on it? I mean, yes, we can have a vote, since that's the procedure here, but as a member, just spontaneously, I would say, if we've opened up this issue and there are a number of comments that I appreciate very much, I think we have the basis for a larger discussion here. But thank you for for reading and for discussing.
Absolutely. Yes, Ms. Rosenblatt, thank you for bringing this to our attention. So I think one of the concepts to keep in mind is that this, this could be voted up or down today. I would like for there to be a vote, unless the proponent of the motion and the seconder withdraw that motion. But at the end of the day, this is not something that is going to continue on in perpetuity as far as this committee goes. So what I would propose doing is directing staff to conduct just a little bit of fact finding in regards to some of the areas we've talked about. And then that can be attached to our final report. So if this does go to a vote, then obviously that recommendation would be made in the report. If it does not go to a vote, then Ms. Rosenblatt, your comments could be submitted as a minority type opinion.
Fine. If I simply want to make a record of this so that the Board of Trustees can consider, and remembering that last time when we did vote on this motion, half the people, there were 13 people absent. So the vote was yes, 0 no, abstain 3. So, and absent 13. So I think that the whole context in which we have discussed the expungement proposal of Sarah Good's committee, and I would appreciate any comment that Sarah might make, it has been only half the people were present. So I think there has been procedurally a situation in which the whole committee wasn't on the same page at the same time. And even now, trying to catch up with that, there's kind of a disjunction procedurally.
Right. And I'm sympathetic to people's schedules getting in the way of being able to, fully lend their experience to these committees. But we do need to continue on with the work, and the people who do clear their schedules to be there and to give comment. We also want to honor those commitments as well. So is it your motion then to withdraw your amendment, or are you?
No, I would like to, if we have to do a vote on it, people can abstain or whatever. But I would like to, and I'll reserve, I think Lisa will advise me on how to make a written record of my comments, and anybody else, a written record of my comments to keep this, advise me, Lisa, on proper procedure.
All right, thank you. Lisa, could we take the roll call then?
Okay, so first one, so we're voting on Ms. Rosenblatt's recommendation?
Yes.
Okay, so let me just share my screen so we know what it is. Okay. Okay, so we're proceeding to vote.
Correct.
Yes, okay. Anderson?
No.
Bell?
No.
Buenaventura?
No.
Buffington?
Abstain.
Abstain? Okay.
Yes.
Okay. I'm sorry, one more time. Buffington?
Abstain. Abstain.
Okay.
Thank you, Ms. Chavez.
Chen? Okay. Duran?
Abstain.
Rashadi? Rashadi? I know Ms. Rashadi's here. Let me make sure she's
No.
Okay. Thank you. Let me just record that. Farwell? Good?
No.
Jones?
Abstain.
Joseph? King?
Yes.
Larkin?
Abstain.
Lawrence?
Abstain.
Lear?
Yes.
Mayorga?
No.
Pierce McGill? Judge Pierce McGill? Judge Pierce McGill? I saw him here.
Sorry, I was on mute.
Go ahead, one more time. Judge Pierce McGill?
Abstain, Ms. Chavez.
Moad?
I also abstain.
Nikal?
No.
Pansky?
No.
Rosenblatt?
Yes.
Schneider? Selig?
No.
Okay, and Judge Wang?
No.
And Mr. Winfield? Okay, he's absent. Okay. So we have 3 yeses, no, 10 no's, and let me count.
Lisa, sorry to interrupt, but I'm going to change mine to a no. I misread something.
Okay. Lear changed to. Oops. Let me count. 1, 2, 3, 4, 5. So we have 7 abstentions, 2 yes, 11 no, and 7 abstentions.
All right, so motion for an amending of the previous decision fails. And that is based upon a majority of the votes cast. All right, thank you everybody for your comments on that. I want to go back then to item A, which is the adoption of moral turpitude recommendations.
So let me share my screen. We'll get started. Okay, so can everyone see my screen okay? If I can, okay. So the Moral Turpitude Working Group met several times, and they held their last meeting actually with the ENEC Working Group, the Early Neutral Evaluation Conference Working Group, because they discovered that they had several issues in common. And at that last meeting, these two groups really just came together to formulate some recommendations. And those recommendations were outlined in the memo that we uploaded to the agenda. And we have 3 recommendations for consideration today, and I'll just briefly go through them. The first has to do with the topic whether or not of a pre-transmittal meeting for misdemeanor criminal conviction cases. The second has to do with the alternative discipline program, and the third has to do with the ENEC. Okay, so let's get started, but let's give you a little big picture here on what moral turpitude is. So according to Business and Professions Code section 6016, states the commission of any act involving moral turpitude, dishonesty, corruption, etc., whether it's fit, etc. Here's what it says. I can't read it because I am suddenly blocking myself from reading my entire screen. Sorry, let me just adjust for a second. Sorry, let me conclude. Whether the act is a felony or misdemeanor or not constitutes the case for disbarment or suspension. And we had several OCTC staff as well as State Bar Court staff present to the various committees, starting with the Effectiveness Committee and down into the Moral Turpitude Working Group, to explain how attorneys can be charged with moral turpitude either as an original matter or when OCTC seeks discipline for a criminal conviction. Now, when the working group members convened, these were the issues that were raised by various members. One, that there was a perception that OCTC overcharges moral turpitude. Second, that respondents experience moral turpitude kind of like a scarlet letter, and therefore they're very hesitant to settle their cases during an ENEC without the opportunity to thoroughly defend themselves. Also, there's this perception, especially among attorneys who represent respondents, is that OCTC has been inconsistent in its willingness to settle cases involving moral turpitude. And then finally, some members raised concern that OCTC does not sufficiently utilize the discretion it has when evaluating criminal conviction cases to transmit to the State Bar Court. And so let's start first with the recommendation regarding the pre-transmittal meeting for misdemeanor cases. Here's the background. And we actually discussed this in several times when talking about criminal conviction cases in the context of the ENEC, etc. But we'll repeat it one more time. According to Business and Professions Code section 6106C, the clerk of the court in which an attorney is convicted of a crime shall, within 48 hours after conviction, transmit a certified copy of the record to OCTC. Within 30 days of receipt, the OCTC shall transmit the record of any conviction which involves or may involve moral turpitude to the Supreme Court, et cetera, et cetera. So I highlighted this here is because the key words here for us in this working group has to do with which involves or may involve moral turpitude. And so in request from members, staff conducted research on criminal conviction cases that reached disposition in State Bar Court to really understand what is going on with cases that the OCTC transmitted to the State Bar Court, to see whether or not what's going on with what was their disposition, et cetera, what percent, for example, were dismissed at the State Bar Court level. And so the research showed that most cases that were transmitted during this time period, which was between March 3rd, 2019 and February 2022, most cases that OCTC transferred during that time, they learned about it through the criminal offender record information process, which is the result of attorneys being re-fingerprinted. And we also learned that nearly all of those cases were based on misdemeanor convictions. Now, among all those cases that were based on misdemeanor convictions, 43% resulted in non-disciplinary action, and nearly all of those cases were dismissed pre-trial. And that's in contrast to only 5% of the cases where the underlying charge was a felony. So, and finally, we also learned that over 2/3 of cases that were based on misdemeanor convictions that were more than 10 years old were disposed of with no disciplinary action. So our members looked at this research and they came to 2 different conclusions. Some members looked at this research and concluded that the system would benefit from a process to resolve cases before transmittal to the state bar court. And staff confirmed that at this time that there is no rule that currently allows for this. The response to this was that the system is actually working as it should. Statute requires OCTC to transmit cases that quote unquote may involve moral turpitude, and that matter is decided at the state bar court. So even though the state high shares of cases are being dismissed by the state bar court, it's happening where it should happen under the process outlined by statute. So one recommendation that one member put forth is as follows. The Ad Hoc Commission on the Discipline System recommends that the board direct staff to work with stakeholders to study possible revisions to all applicable rules to determine the feasibility of conducting a pre-transmittal meeting similar to an ENEC in criminal and misdemeanor criminal conviction matters, subject to these rules, that would determine whether or not the facts and circumstances underlying the misdemeanor conviction involve moral turpitude or other misconduct warranting discipline, and if appropriate, evaluate a potential disposition of the matter. So kind of a mouthful, hopefully you all read this beforehand, but they're basically recommending that staff work with stakeholders to come up with a process that these cases can be resolved before, or discussed, et cetera, before a transmittal to the state bar court. And before we open up for discussion of the recommendation, let me share the arguments pro and con. So here on the left are the arguments in favor. Members argue that first and foremost, that such a process is going to benefit respondents. It allows for cases to be resolved privately because right now, even if a case is dismissed at the state bar court, that filing remains on the court docket. Respondents will then no longer incur discipline costs associated with being having a matter held in state bar court. As you recall, that we discussed costs in depth with, and actually this commission actually adopted a recommendation addressing these costs. And also respondents will have lower costs associated with retaining counsel to defend themselves in state bar court. And then finally, they point out that the state bar court and OCTC would benefit from having a process in place because they would save resources from going to trial. So on the right here, here's the opposition. So first and foremost, the statute directs OCTC to transmit, so the decision is really vested with OCTC. Scheduling such a meeting is really impractical given the 30-day statutory deadline. Yes, this commission adopted a recommendation to promote statutory change where that deadline would be extended, but this member argued that extending that deadline is pretty unlikely. That granting the extension is very unlikely. Finally, members pointed out the public protection is served best by publicly noticing transmittal of C cases and resolving the issue in public. And then finally, nothing is preventing respondents to outlining the facts and circumstances when they self-report their criminal conviction matters. Okay, so let's just go ahead and have a discussion about this. And at this point, maybe we could just welcome, I really hope, Ellen Pansky, that I captured all of, I know you were really instrumental in sharing your experiences as a response attorney, different, et cetera, and also, as well as people who were opposed to this recommendation. I really hope that I captured all of your the issues appropriately. Thank you.
All right, I see that Ms. Pansky's hand is raised, so go ahead.
Thank you. Thank you, Lisa. I think you did a very thorough job and accurate job of summarizing the discussion. I just want to emphasize that the working group came together to make this recommendation for the board to consider, or requesting that the board create a working group at which all of the staff holders, not just state bar staff, would be participants to explore this further. And just to highlight a couple of the points, a great number of misdemeanor convictions involving lawyers either have no nexus to the practice of law or are something, excuse me, as the statistics point out, that resulted from an incident that occurred many years ago. And so the overarching concern is that a lawyer who's already been through the criminal justice system, who's already received a disposition through the criminal court system, and whose act, for example, a DUI conviction, other misdemeanors that you might consider to be more minor, like trespassing, for example, not result in professional discipline if the incident occurred under mitigating circumstances a long time ago, and there's no current suggestion that the lawyer poses any kind of threat to their clients or the public. The idea of this is to save resources, not just for the respondent, but for the state bar court system itself, and also for the prosecutor. A high number of these cases, as the statistics indicate, resolve for either a dismissal or some other low-level disposition. So if the parties have an opportunity with the assistance of the court to try to resolve these matters at an early stage, it is to everyone's benefit. And there is no recommendation other than allowing the parties to come together and to come to hopefully some creative solutions that allows a more efficient and productive system and a better result for both the respondent and the disciplinary system. Thank you.
Okay, so it looks like the item says that if there was a vote to be taken on this, that the direction would be from the commission that staff work with the stakeholders to study these possible revisions. So is there a motion then for this item?
I move approval of the recommendation.
Okay. Is there a second?
I second the motion.
All right. First by Ms. Pansky, second by Ms. Anderson, I believe.
Yes.
All right. Lisa, can we have a...
Yes.
Okay, let's put the item up there and then we'll...
I will. Okay. I just lost it there for a moment. Okay. Okay, ready to vote? Okay.
All right. Yes, please take a roll call vote.
Okay. Anderson?
Yes.
Bell?
Yes.
Buenaventura?
Yes.
Pardon me?
Yes.
Buffington? Buffington? Chen? Duran?
Yes.
Rashadi?
Yes.
Farwell? Good?
Yes.
Jones?
Yes.
Joseph? King?
Yes.
Larkin?
Yes.
Lawrence?
No.
Lear?
Yes.
Mayorga?
Yes.
Judge Kirsch McGill?
Yes.
Moad?
No.
Nakao?
Yes. Yes.
Thank you. Pansky?
Yes.
Rosenblatt?
Yes.
Schneider? Selig?
Yes.
Judge Wang?
Yes.
Winfield? Okay, so that's 17 in favor. The motion passes.
All right. Thank you. All right, Lisa, can we go on to the next agenda item then?
Yes. Okay, so let me.
Or at least the next recommendation.
Yep. Let me just gather myself here. Okay, sorry, excuse me. Okay, so the next recommendation has to do with the alternative discipline program, and here's some background there. So attorneys who are accepted into the alternative discipline program are required to participate in treatment with the lawyer's assistance program for 3 years, and that may be reduced to 18 months depending on incentives, etc. And the key here is that upon successful completion, respondents can earn a lower level of discipline than would otherwise be imposed. Now, the reason why this relates to our discussion on moral turpitude is as follows. Members raised issues about 2 rules that they feel need some clarification. First is Rule 5.382 C3, and it discusses how who's ineligible for ADP. And in particular, here's the rule. An attorney is ineligible to participate in ADP if the attorney's misconduct involves moral turpitude, acts of moral turpitude, dishonesty, or corruption that have resulted in significant harm to one or more clients or the administration of justice. There's another rule, Rule 5.382A2, that says participation in ADP is also contingent upon the court's approval of a stipulation of facts and conclusions of the law signed by the parties. So the concern raised by members is that when there's a dispute between the parties whether or not moral turpitude was committed, a stipulation cannot be reached. So therefore, the second rule listed here effectively disallows participation. And so a few members proposed the following recommendation: that the Ad Hoc Commission on the Discipline System recommends that the rule involving referrals to ADP be clarified to allow for judicial determination of eligibility following an evidentiary hearing. And the reason why they promoted this is that ultimately doing so would expand opportunity for rehabilitation as directed by Business and Professions Code section 6230, and that's listed here, that the code says it is the intent of the legislature that the State Bar of California seek ways and means to identify and rehabilitate attorneys with impairment due to substance abuse or mental health disorders affecting competency, so that attorneys so afflicted may be treated and returned to the practice of law in a manner that will not endanger the public health and safety. So the opposition to the recommendation was just simply that this would potentially create an additional burden for OCPC if eventually the trial is needed. So in effect, it would be kind of like having two trials. There would be very duplicative efforts, especially when it comes to calling witnesses. Often these cases require witnesses, and the witnesses would need to be called twice if eventually this matter did proceed to trial. So there were actually two alternative recommendations to that first one. Here on the left is one that, like it's here on the right, just basically is stressing that this evidentiary hearing would not be needed in every case. And so that recommendation reads similar. It's like the rule involving referrals to ADP be modified to make clear that eligibility is subject to judicial determination following, if necessary, an evidentiary hearing. So the if necessary part, which was added to this recommendation. And then this last recommendation here, or rather another alternative, really makes explicit that the evidentiary hearing would be part of the discipline hearing. It reads as follows, just a little bit more details here at the bottom. And then finally, staff proposed a recommendation that is kind of similar to the recommendation you just passed, which is just the Ad Hoc Commission on the Discipline System recommends that the board direct staff to work with stakeholders to study and clarify all applicable rules involving referral to ADP, specifically concerning whether or not moral turpitude has resulted in significant harm to clients or the administration of justice. So staff recommendation, just direct staff to work with stakeholders to study and provide clarity on the rules. It really kind of widens the scopes of possible solutions. So it's not about naming an evidentiary hearing, et cetera. It's just, really widens the scope of possible solutions. And it really narrows the focus to ensure that we are talking about moral turpitude here. So, we have a discussion this, and again, this is thank you. I just want to thank Rachel Grunberg of the State Bar Court, who really helped me write up this section.
All right, is there anybody who would like to start out? And I'm going to call on Mr. Saleg.
Thanks, Brandon. So my view, and based on having discussions with people behind the scenes, is this is an area that's worth studying. I don't think this commission, that we've really laid the groundwork to make a substantive decision on this. So I will move adoption of the staff proposal, which is that the commission direct the board, that recommend that the board direct staff to work with stakeholders to study this further. And I think that's the best outcome for us.
All right, thank you. Is there a second?
Second.
All right, second by Mr. Larkin. Any further debate? All right, I see no raised hands. So Lisa, can you please put up the proposed language?
Whoops. It's right here. Okay. Sorry, should I would everyone feel better if I created like just a clean slide really fast just to ensure that that's what we're, let me just do that. To be official here, right? Sense. Okay. Let me share my screen. Here we go. Here's the resolution. Okay, ready for vote?
Yes, please take a roll call vote.
Okay, terrific. Anderson? Anderson?
Yes.
Bell?
Yes.
Buenaventura?
Yes.
Buffington?
Yes.
Chen? Duran? Duran?
Yes.
Urshadi?
Yes.
Farwell? Good?
Yes.
Jones?
Yes.
Joseph? King?
Yes.
Larkin?
Yes.
Lawrence?
Yes.
Lear?
Yes.
Mayorga?
Yes.
Judge Pierce McGill?
Yes.
Moad?
Yes.
Nakau?
Yes.
Pansky?
Yes.
Rosenblatt?
Yes.
Schneider? Saleg?
Yes.
Judge Wayne?
Yes.
Winfield? Okay, the motion carries with 20 yeses.
All right, thank you. I knew when I voluntold Sean to put his skills to work in this area, I knew that he would get some consensus. So great work, Sean. I appreciate your help in this. All right, Lisa, can we move on to the next set of recommendations?
Okay, here's the last one. Okay, so this recommendation has to do with the Early Neutral Evaluation Conference. Now, just keep in mind, we had a whole other working group regards to early neutral evaluation, but this group came together with the Moral Turpitude Working Group when they saw that they had the issue, something in common, and this is the issue. Members representing respondent attorneys assert that the ENEC process needs to be revamped, and they gave examples of what they have experienced with their clients. First, they're concerned that OCTC is not bound to follow judges' judicial evaluations, even those that raise concerns regarding lack of evidence to support moral turpitude charges. And two, in their experience, OCTC attorneys have been inconsistent in their response to judicial evaluations, with some willing to negotiate and others stating that they have no authority to negotiate. So this was a recommendation put forth by some members. Here it is. The Ad Hoc Commission on the Discipline System recommends that the board direct staff to work with stakeholders to propose revisions to all applicable rules to promote the use of the Early Neutral Evaluation Conference as a mechanism for arriving at pre-filing settlements of state bar disciplinary proceedings. And those in favor say that by doing so, pre-filing settlements will increase, and that will conserve OCTC and state bar court resources. This will result in faster and less expensive resolutions for respondents, and also responding to moral turpitude allegations before a case becomes public increases fairness in the system. And those in opposition to this resolution say that first, there is no way of knowing if changes to the process will result in greater conservation of resources. They point out that the ENEC process delays the filing of an NDC and ultimately case resolution. Someone noted that no other regulatory agency in California offers an ENEC, and she viewed the process as a detriment ultimately to public protection because it delays public notification of misconduct allegations. And then finally, expanding the process is essentially increasing respondents' attorneys' rights and decreasing public protection appetite for them. Okay, so those are there's no alternatives to this recommendation. Here's the recommendation right here, and we have a discussion now.
All right. Does anybody have any statements, comments, questions for staff? Any motions in favor?
I'll move approval.
Ms. Pansky.
I'll move approval of the recommendation.
Second.
All right, first by Ms. Pansky, I'm going to give the tie to Sean. Sorry, Mr. Chair. All right, Lisa, can you please put up the language?
Okay, we can proceed to a vote.
Yes.
Okay. Anderson?
Yes.
Bell?
Yes.
Buenaventura?
Yes.
Buffington?
Yes.
Chen? Duran?
Yes.
Rashadi?
Yes.
Barwell? Good?
Yes.
Jones?
Yes.
Joseph? King?
Yes.
Larkin?
Yes.
Lawrence?
No.
Lear?
Yes.
Mayorga?
Yes.
Judge Kirsch McGill?
Yes.
Moad?
No.
Nakau? Nakau?
Yes.
Kansky?
Yes.
Rosenblatt?
Yes.
Schneider? Soleg?
Yes.
Judge Wang?
Yes.
Winfield? Okay, the motion carries with 18 votes yes, 2 no.
All right, thank you, everybody. We'll now go to item D, which is review and approval of the commission's final report. So Lisa, I'll give you a couple of seconds to get situated there.
Okay, let me just. Okay, sorry, let me just get my slide up here. Okay. Okay, so per the charter that established the ad hoc commission, your commission has a final report due to the Board of Trustees. And we have the deadline extended to September 30th, 2022. I believe the deadline was earlier this summer. Today, we're going to review edits received thus far. So far, I've received comments from a few commission members, and I'd like to share those with you. We're going to confirm that recommendations will be added to the report. And then we also can open it up to the floor to make substantive edits, any that you may have at this time. And the reason why we're calling out substantive edits is because if you have a substantial edit to add to this report, it's important that we incorporate it into the report, because so then therefore you approve the report based on the substantive edits that you see being made in live time. Going forward, we welcome any technical or clarifying edits, and this is totally optional, and you can send those to me by next Friday, September 2nd. And again, the reason why we're distinguishing between substantive edits and technical and clarifying edits is because you all we're asking you to review, to approve the report today. And so any edits that are going to happen after this should be really just kind of technical and clarifying rather than substantive. And also, as we mentioned earlier, anyone on this commission has an opportunity to submit a written dissent. And that's something that we will add to the report with no editing from staff. We're simply going to attach it as a PDF. And that too is due next Friday, September 3rd, 2022. Okay, for now, does anyone have any questions about what we'll be doing next? Okay, terrific. Okay, so let me get myself situated because I do want to share the edits that I've received so far. Let me just close that so I don't. Okay. Okay, so so far we just received comments from 3 people. The first comment had to do with on page 21. swapping out the word for the word to here, and I believe this sounds about it. I mean, it's technical, it's clarifying, but it's also just something we felt we needed to share with you. Here on table 4, page 25, received great feedback that we neglected to list Judge Wang as a member of the ENEC working group. So we've added her to the report. And also noting that we neglected to list 2 meetings, working group meetings. And so we went ahead and added those to the list of the ENEC working group meetings. We added September 15th, 2021, and then also to the progressive discipline list of meetings that working group, we added December 16th, 2021. Thank you for those comments. And then finally, we have Judge Pierce McGill. As you know, he gave a presentation to you all on State Bar Court, and he sent over a list of edits to that section that described his presentation. And I'm just going to go ahead and share that for you now because I've already incorporated, I'm going to share those with you right now so you can see those. Oh, gosh. Excuse me. Okay. I'm just going to close my PowerPoint because it just keeps showing my PowerPoint. Okay. Okay, so let's go ahead and find Judge. Okay, so here's the edit from Linda Schneider right here. So remember, as I said, applying, she swapped out for a 2, and I think it makes sense, running for public office or applying to a licensing agency rather than for a licensing agency. Here's table 4. Adding Judge Wang here and adding the dates of the meeting for an ENEC that we neglected to include. And then here's the. I don't know if it's just me, but we're looking at a Word document that looks like Judge McGill's edits. Okay, sorry. Let me just close that out so this way we don't. Okay, thank you. How about now? Are you looking at a table? Yes. Okay, great. Okay, so let's start from the top then. Thank you for that, Leah. So here is, okay, so let's start from the top. Here's Linda Schneider's edit, where she swapped out the word for and replaced it with, recommended replacing it with 2. So I think this makes sense because it's running for public office or applying to a licensing agency rather than for a licensing agency. Here in table 4, well, actually, sorry, before we get to table 4, we'll just read, these are Judge Pierce McGill's edits to the section on perception of state bar for independence. I can make my screen bigger so everyone can see them. Yes, I'll give you a moment to review these and see if does anyone have any particular questions or concerns for Judge Pierce McGill. I don't see any answers. No? Okay.
Yeah, I think those edits are fairly in line with everything that's been discussed. So looks great. Thanks for your work on this, Judge McGill.
Okay, great. And then here in table 4, we added Judge Wang to the list of members of the Early Mutual Evaluation Conference Working Group, added September 15th as one of the meetings. And then also for Progressive Discipline Working Group, we added a date here. That, oh, look at that. Okay. December 15th, 2021. So it turns out the Progressive Discipline Working Group did meet 2 times. We thought it only met once. Okay, so now is your opportunity to, offer any substantive edits you'd like to see, and we can. Goal is to just add them here in lifetime.
And also keeping in mind that we're not going back and changing any of the decisions that have been made, but it's rather just not a reopening of debate, but rather just the way something has been articulated. If there's any differences of opinion in that, I will say that I know that staff has put in a lot of work, particularly Lisa, and going back and listening to the meetings and really trying to capture exactly the tenor of the discussion and not just what was said, but how it was said. And And so I want to commend staff for the enormous amount of work. Lisa, thank you for picking up this project kind of midstream and putting your touch on it. So any questions or comments? Give members another couple seconds. All right, I don't see any hands here. All right, so Lisa, do we vote on this, or is this?
Let me show you the resolution that we have for your consideration. Here's a resolution for your consideration. The Ad hoc Commission on the Discipline System approved the Commission's final report, allowing for final edits pursuant to discussions held and recommendations adopted during its October 24th, 2022 meeting, as well as clarifying and correcting edits by staff and Commission members.
All right, and I do just want to make a comment as to that last kind of half paragraph, the clarifying and correcting edits. This is something that we have done in the past at the Board of Trustee level and other commissions, I believe, in compiling reports and just giving staff a little bit of leeway, you know, as far as non-substantive changes from what I understand. So, all right, do I have a motion on this resolution?
I'll make a motion that the Ad hoc Commission on Discipline System approve the Commission's final report.
All right, first by Ms. Anderson. Is there a second?
Second.
All right, second by Ms. Pansky. All right, everybody has the resolution in front of them now. This is what we're voting on. Lisa, can you please take the roll?
Sure. Anderson?
Yes.
Bell?
Yes.
Buenaventura?
Yes.
Buffington?
Yes.
Chen? Duran?
Yes.
Rashadi?
Yes.
Farwell? Good?
Yes.
Jones?
Yes.
Joseph? King?
Yes.
Larkin?
Yes.
Lawrence?
Yes.
Lear?
Yes.
Mayorga?
Yes.
Judge Kirsch McGill?
Yes.
Moad?
Yes.
Nakow?
Yes.
Kansky?
Yes.
Rosenblatt?
Yes.
Schneider? Stalag?
Yes.
Judge Wang?
Yes.
Winfield? Okay, so the resolution passes with 20 yeses. And no, 0 no's. Okay.
All right, that concludes the business for today's meeting of the Ad hoc Commission on the Justice System. So thank you for your participation today. I know everybody has incredibly busy calendars and impacted schedules. So to move this group as one is a mighty effort indeed. So thank you for your participation. And then we will, when is the next meeting?
So we're going to be convening your last meeting in early December to review public comments that may be received during the 60-day public comment period.
So just watch your emails in for some polling emails for your schedule. So thank you so much. Have a great rest of your day.
Brandon, if I could just chime in and mention it, I do want to recognize Lisa. She's done an incredible job, and I think all of you know it's been very difficult to pull the meetings together and get this material written in a coherent fashion. So I want to recognize and thank her. I think you guys have put together ultimately a very solid set of recommendations. And I'll be really interested to see what the board as a whole thinks, and then the public when we send these out for public comment. So thank you, Lisa.
Thank you.
Okay, bye-bye. Thank you.